Your Excellencies, Chief Justices, Honourable Judges, members of the Foreign Diplomatic Corps, Honourable Ministers, ladies and gentlemen. On behalf of the Asian Development Bank and UNCITRAL and all of our conference partners, welcome to the third South Pacific International Arbitration Conference. Welcome to Sydney and welcome to the Sydney Opera House. My name is Daniel Meltz and I'll be hosting the conference today and speaking a little bit later in the session. By way of introduction, I am a practicing Sydney-based arbitration barrister and I'm privileged to hold a consultancy with the Asian Development Bank on arbitration reform in the South Pacific, together with my esteemed London-based colleague, Gary Bourne. As we enter the fourth year of this reform work, driven by the Asian Development Bank and under the leadership of Principal Counsel Christina Pack, this conference is an opportunity to reflect on what has been achieved to date and explore the possibilities arbitration might bring the South Pacific into the future. Nothing speaks more eloquently of the interest in arbitration reform in the South Pacific than the fact that today we have conference participants from over 40 countries tuned into this event. We have nearly 300 participants today by Zoom and we welcome you today as well. Our morning session comprises opening remarks from Mr. Thomas Clark, the General Counsel of the Asian Development Bank, and Ms. Commandar of UNCITRAL. And this will be followed by our keynote address from the Secretary General of the ICC, Mr. John Denton, who I'll introduce a little later. But before we do so, we have been warmly welcomed in the South Pacific during the course of our work to your countries. And now we welcome you with a traditional welcome to country from a distinguished elder of our Indigenous community, Aunty Ann Weldon, who will talk to you about the land on which we stand.
Thank you very much, and good morning, or not too sure of the time in other parts of the world, but it certainly is a glorious day. Well, not too glorious, but we're in the most incredible spot here in Sydney, one of the best in Australia. Today I stand before you on the land of the mighty Eora Nation, and I am a Wiradjuri Koori Balang. Wiradjuri is one of the mighty Aboriginal nations here, actually in New South Wales, and Balang is woman in my language, and Koori, of course, is Aboriginal. It is with the permission of Metropolitan Local Aboriginal Land Council, who is the cultural authority and custodian under the New South Wales Land Rights Act, of the land that I stand before you on and join you here this morning at your conference. And this morning I bring you a message of respect and of caring. And it is important to acknowledge this country's rich, first and original story. So I would like to pay my respects to all elders, past, present and emerging, from all of our Aboriginal and non-Aboriginal people and nations from around the South Pacific, and express my gratitude for the sacrifices that have been made by our elders to create a better quality of life for all peoples in our country and indeed their countries. It is a humble privilege for me to provide a welcome to country. For me it is a profound honour and a luxury of time. Time that has been given by you and time that has been given by many warriors that started the traditions for everyone. And a welcome isn't just words, it's a reflection of where we are. Not this modern day structure, but the continuous link of life, lesson, purpose and nurturing supplies. And the boundaries of traditional owners are not defined by the hand and a pen, but through the natural landscape of our incredible country here in Australia. For the Eora Nation country spans from the Hawkesbury River to the north, the Nepean to the west and the Georges River to the south. So on behalf of Metropolitan Local Aboriginal Land Council and members, I welcome everyone to the land of the Gadigal people and the Eora Nation. For the Gadigal people, whose spirits and ancestors will always remain within their land, our Mother Earth. And whenever you travel this incredible continent of ours here in Australia, you are entering the land of a nation, a tribe and a clan which have existed and belong to these lands that stretches far beyond 65,000 years. First Nations of this land, we are the most diverse, unique and sustainable people on the planet. We are the oldest living culture of the world, and it is important to acknowledge this country's rich, first and original history. So let me pay homage to the many warriors that created pathways for all of us, the ones recognised and the ones that we have never heard of. And our journey and milestones will only be realised if we can see, if we can feel, and if we can be a positive difference put into real action. And we must commit to making our world, our society inclusive, breaking through barriers, not creating them. For all of us together can bring about changes, starting with the multiple generations and healing of past generations, and by declaring what should not have taken place to our present-day generations, giving them hope. For our creators have shown a way to creating a better future for the next generations, for everyone in our country. But sadly, the lessons have been learnt at our expense, and our devastation should and must be acknowledged. But to listen, learn, and to come together to heal and prevent heartaches from ever happening again. So as you connect, learn and share today, tomorrow and beyond, don't live regretting what should have been done, but create the legacy of what must be done. For our future is only as good as our history, and we need to reflect upon the footsteps that we are leaving to know where we are heading and to shaping a world that we can all be very, very proud of. And the truth needs to be told, but it must be heard if we are all to walk together. So join me by learning from the ancient and living teachings of these land's first people, and you can all draw upon my people's spirit as we continue on our journey together. For we believe that our ancestors walk beside us, guiding us and light our way, and we ask that you walk beside us. Please do not walk ahead of us and allow my people, Aboriginal Australia, to certainly share the wealth and prosperity that our country has to offer. I also take this opportunity to thank the third South Pacific International Arbitration Conference organised for inviting me and, more importantly, Metropolitan Local Aboriginal and Council to conduct a welcome at your incredible event. I wish you every success, and no doubt you'll certainly come up with some brilliant proposals and, ensure that our country certainly prosper. So once again, welcome to the land of the Eora Nation and Gadigal people. And I thank you, for all of you incredible people that are not here in the room, but, in the South Pacific. Thank you very much. I'm very humbled to have had the opportunity. Thank you.
Thank you very much, Aunty Ann, for that welcome to country. We're deeply appreciative. I'd like to introduce now Mr. Thomas Clark. Mr. Clark is the General Counsel of the Asian Development Bank. Mr. Clark has had a distinguished career. He's a graduate of Columbia University and Harvard University. He has worked in very important law firms in the United States, Sullivan & Cromwell and Wilmer Hale, before having his career at General Electric, GE, for some 22 years. After that, Mr. Clark was Managing Director and Co-Head of Americas for the Global Public Policy Group of BlackRock, Inc., which is the world's largest asset management firm. And we welcome Mr. Clark and his comments, and we thank the ADB as well for their support in relation to this, the third conference. Mr. Clark.
Thank you very much. Good morning, honourable ministers, honourable members of the judiciary, dignitaries, distinguished guests, ladies and gentlemen. Mabuhay. Good morning from Manila. My name is Thomas Clark, the General Counsel of the Asian Development Bank. Thank you very much for that kind introduction. I'm delighted to be here with all of you, gathered at the Sydney Opera House and via Zoom from over 30 locations from around the region and beyond. ADB is honored to be partnering with the Australian government, the United Nations Commission on International Trade Law, or UNCITRAL, the International Chamber of Commerce, the Australian Centre for International Commercial Arbitration, and the Singapore International Arbitration Centre to bring all of you together for this third South Pacific International Arbitration Conference. Indeed, this is truly a remarkable, important gathering of key government officials, policymakers, judges, lawyers, private sector and development partners, and indeed all of the world's foremost experts on international arbitration to engage in a dialogue to help lift barriers to foreign direct investment and regional and international trade in the South Pacific region and Timor-Leste. As Pacific developing member countries and Timor-Leste chart a course toward a post-pandemic recovery, efforts to increase foreign direct investment and cross-border trade and improve the overall business climate for private sector development have become even more critical. Now, since 1966, the ADB has been committed to the South Pacific region and Timor-Leste, and the region comprises, indeed, almost one-third of ADB's developing member countries. ADB has more than 64 ongoing projects, finance sovereign projects across our Pacific developing member countries, with financing exceeding $2.9 billion US. This is more than a six-fold increase over the $448 million portfolio that we had just as recently as 2005. I'm also pleased to note that ADB is now the Pacific's largest single source of renewable energy financing. And in Timor-Leste, ADB has more than 70 ongoing projects with financing exceeding $430 million. Now, moreover, to assist ADB member countries and to help them respond to the COVID-19 pandemic, ADB has provided numerous, indeed many very significant support, including the immediate grant support to purchase much-needed PPEs, medical supplies, and quarantine facilities, budget support to finance crisis-related fiscal matters, and policy-based support to strengthen macroeconomic resilience, along with contingent disaster financing funds and active management and engagement with the private sector, including reaching out to financial institutions and companies such as agribusiness, infrastructure companies to discuss COVID-19 impacts and requirements for potential ADB financing. And as mentioned, private sector investment is really critical for economic growth and job creation. We all know the importance of the private sector and the importance of mobilizing and crowding in private capital. And in this regard, I note that ADB is working to improve the business environment, including ways to attract more foreign direct investment and cross-border trade, which has become even more vital with COVID-19 recovery efforts. For example, this work is supported by ADB's Private Sector Development Initiative, or PSDI, a regional technical assistance program undertaken in partnership with the Government of Australia and the Government of New Zealand. Since 2007, PSID has been working to reduce constraints to doing business and to promote private sector growth in the Pacific region, such as helping to streamline business registration processes, enable movable assets financing, and to promote entrepreneurship and foreign direct investment. Alongside ADB's operations, the Office of the General Counsel manages a law and policy reform program in which we design and implement technical assistance projects to work with our developing member country partner governments. Now, these technical assistance projects are aimed at modernizing the legal systems to encourage investment and trade and facilitate commercial activity and to build the capacity for judicial and legal institutions. This is a very important medium to long-term strategy that complements our investments in the financial area and with financing resources. This knowledge component is really critical for ADB. Now, as you know, a major factor, a major barrier in attracting foreign direct investment and stimulating cross-border trade is the lack of investor confidence in available, effective, and efficient ways to resolve and enforce commercial disputes between people from different countries. In recent decades, international arbitration has become the preferred means of resolving international commercial disputes all over the world. However, the South Pacific is still one of the last global regional blocs without a cohesive legal framework to resolve these cross-border commercial disputes through international arbitration. This form of cross-border dispute resolution and enforcement regime, I would argue, is fundamental, absolutely critical to foreign investment and dispute resolution, and the enforcement regime is going to be key. The absence of this international arbitration framework indeed increases the risks and the costs of doing business and stifles economic growth potential across the region. To assist our Pacific developing member countries and Timor-Leste to put in place an international arbitration legal framework, we've been very busy and very involved across the last many years. In 2017, ADB launched a technical assistance project under our Law and Policy Reform Program to help accede to the New York Convention and to put in place the implementing arbitration law and to provide capacity building to judges, lawyers, and private sector as implementing parties. Since 2017, there have been many positive developments, starting with Fiji's enactment of the International Arbitration Act in September of 2017, followed by a accession to the New York Convention by Papua New Guinea in July of 2019, a accession to the New York Convention by Palau in March 2020, a accession to the New York Convention by Tonga in June of 2020, and the enactment of Tonga's International Arbitration Act just this February of 2021. So as you can see, this is a path that we are continuing to follow and walk side by side along our partners among our developing member countries and Timor-Leste in the region. Now, we also hoped here to convene the first of its kind, first South Pacific International Arbitration Conference. And we helped convene that first of its kind conference in Fiji, hosted by the Fiji government. And then the second South Pacific International Arbitration Conference hosted by the PNG government. All of this to raise awareness about the importance of this reform to the South Pacific region, as we have also developed and delivered numerous capacity building programs to judges, lawyers, and the private sector over the last 3 years. Of course, I hope you'll understand that all of these wonderful results would not have been possible without the support of our development partners, including our long-standing partner, UNCITRAL, as well as the international arbitration community. We are extremely grateful for that partnership and for the great teamwork, I think, that all of these groups have shown together with ADB to deliver these programs of vital importance to the region. I will just conclude by saying that today we will hear from key business leaders and some of the foremost experts in the world on international arbitration and legal reform, and we will discuss the issues and challenges and share knowledge on best practices. I'm very grateful also to our own Christina Pak, heading up Law and Policy Reform Office, and to all of the many people who have contributed to this program. Let's please use this incredible opportunity to work together towards a common objective that can produce substantial benefits to the people and the countries of this region. On behalf of the Asian Development Bank, I would like to thank all of you for coming to this conference and for your strong commitment to this region. I wish you a tremendous and very successful conference. Thank you very much.
Thank you very much, Mr. Clark, for those words, and we're, again, very grateful for your support. And as you mentioned in your talk, we are also partnered by UNCITRAL, and we are very mindful that when we perform these reform tasks, that we are working with two United Nations documents, the New York Convention and the model law, developed over many years and much thought that has gone into the development of particularly the model law, and we thank you for your support in that. I now turn to Ms. Athita Commanda, who is the head of the Regional Centre for Asia and the Pacific United Nations Commission on International Trade Law, UNCITRAL. Ms. Commanda is the, as I mentioned, is the head of the regional agency. She has a long development background, particularly working with the government of Thailand, and has represented previously Thailand in regional multilateral trade negotiations with the WTO. She is admitted in New York and is a graduate of Harvard and Georgetown and Harvard Law School. And we welcome you and we look forward to your comments. Thank you, Ms. Commanda.
Thank you very much, Daniel. Thank you. Thank you for my slides as well. Thank you. Yes, if we could stay on the cover page. Thank you very much. Thank you. Excellencies, ADB and ICC colleagues, distinguished speakers, and friends of UNCITRAL. Greetings from the UNCITRAL Regional Center for Asia and the Pacific in Incheon, Republic of Korea. It is an honor to join you this morning to celebrate the ADB's successful technical assistance program for the reform of laws on international commercial arbitration in the South Pacific. UNCITRAL is honored to have been a partner in this journey since its 2017 launching. When I myself joined UNCITRAL RCAP in 2019, the second South Pacific International Arbitration Conference was my very first mission after landing in Incheon for only a week, which highlights the importance that UNCITRAL gives to commercial law reforms and legal harmonization to further facilitate trade and de-risk investment in this beautiful region. Next slide, please. Since then, the UNCITRAL and ADB collaboration has proven extremely successful in the Asia-Pacific region. Cumulatively, our technical assistance activities and legislative reviews have led to 4 new regional ratifications of the New York Convention, 3 of which are in the South Pacific, Papua New Guinea, Palau, and Tonga, and 40 Asia-Pacific jurisdictions adopting the model law on international commercial arbitration, an increase of about 33% since 2015. The strong regional interest in enforcing contractual obligations via a predictable and neutral dispute settlement regime has also led to the successful launching of the Singapore Convention on Mediation, with over half of the 53 signatories and 4 of the 6 state parties hailing from the Asia-Pacific and the South Pacific. The South Pacific's achievements in this regard contribute to the 2030 Agenda for Sustainable Development, and in particular, Sustainable Development Goal 16, enhancing access to justice and contributing to the development of a mature, rule-based global commercial system. Can we skip the next slide and go to slide 4, please? But we should and will continue to aim higher. While 3 South Pacific states have joined the New York Convention since 2017, UNCITRAL stands ready to assist those who have not yet joined, whether through awareness-raising webinars, government and judicial briefings, or legislative reviews. With near universal participation by 167 states, the latest being Malawi, the New York Convention, of which UNCITRAL is the gatekeeper, provides common legislative standards for the recognition of arbitration agreements and court recognition and enforcement of foreign and non-domestic arbitral awards, subject to only specific limited exceptions, and thus facilitates the resolution of disputes in all corners. Next slide, please. The same holds for the UNCITRAL model law on international commercial arbitration. First adopted by the United Nations General Assembly in 1985 and most recently amended in 2006, the model law is a freestanding arbitration statute that establishes a unified, fair, and efficient legal framework reflecting worldwide consensus on the principles and important issues of international arbitration practice, while providing flexibility for enacting jurisdictions. It covers all stages of the arbitral process and conforms to current practice in international trade and modern means of contracting with regard to the form of arbitration agreement and the granting of interim measures. As of March 2021, legislation based on the model law has been adopted in 85 states in a total of 118 jurisdictions. Enacting South Pacific and Asia Pacific states include Australia, Fiji, New Zealand, China, India, Japan, Republic of Korea, Singapore, and many others. For more details, you may be interested in perusing UNCITRAL's digest on the model law, available via the web link shown here. The digest was launched in 2012 and is usefully organized according to the model law chapters and article. It provides a summary of case law for each article, highlighting common views and reporting any divergent approach, and includes 725 cases from 37 states all over the world. The Secretariat is also working on a new version of the digest, so please check back on our website. We also publish more recent cases on the model law in the UNCITRAL Clout digital database, case law database, also accessible on the UNCITRAL website in all 6 of the United Nations languages. Let's skip the next slide and go to slide 7, please. For our South Pacific participants who are interested in learning more about UNCITRAL dispute resolution instruments, I invite you to join our upcoming virtual events throughout the region, starting from an ADR webinar with Bangladesh next month to our flagship technical assistance and capacity building activities with the Korean Ministry of Justice and Hong Kong SAR Department of Justice from September onward. Many of you have participated in the UNCITRAL ADR special session held in Seoul, either in person or online, and we invite you all to attend this year's edition as well. Next slide, please. For our academic colleagues in the South Pacific, UNCITRAL RCAP invites you to co-host an event under the UNCITRAL Asia Pacific Day flagship academic series. This is an annual event aimed towards students and young professionals that RCAP co-hosts with institutions of higher learning in the last quarter of every year on a wide range of UNCITRAL thematic issues, such as arbitration, mediation, sale of goods, e-commerce, and many others, with a format ranging from in-class lectures to multi-day regional academic conferences. We skip to the last slide, please. Finally, UNCITRAL RCAP invites those of you interested in learning more about UNCITRAL or co-hosting an activity with UNCITRAL RCAP to reach out to us anytime via email, noted there, and to subscribe to our mailing list via the QR code seen there. Thank you again to the ADB for giving me the honor of delivering these co-opening remarks on behalf of UNCITRAL, and I wish the conference every success. Thank you very much.
Very much for those comments. We now turn to our keynote speaker, John Denton. Mr. Denton is the Secretary General of the International Chamber of Commerce. The International Chamber of Commerce, of course, is the peak global business body. It represents some 45 million businesses in 100 countries. Mr. Denton, as I said, is the Secretary General. He is also a board member of the United Nations Global Compact and co-chair for Financing Growth. He has a distinguished career as a diplomat before becoming a partner and chief executive of a large law firm in Australia for a number of years. In 2015, he was appointed an officer of the Order of Australia for his services to the business community, the arts and the rights of refugees. Mr. Denton is a graduate of Harvard Business School and the University of Melbourne. Mr. Denton, over to you.
Hola, I'm speaking to you from Madrid, and I'm deeply sorry that I can't be live and in person in the South Pacific, from which I come, and I often think about my engagement with the South Pacific and how formative it has been in my life, and how much I've always enjoyed the company of my friends from South Pacific. So I'm sad in a way that I can't be with you. But of course, that's one of the challenges of the period, the context, the world we live in now, and none of us will be safe until we are all safe. And I think many of you will know that I have been leading at the ICC efforts on a global level to ensure the equitable access to vaccines for all, because we think that without ensuring that is the case and that happens in a timely manner, then this context in which we operate will not finish, will not end. We will not be able to move around. We will not be able to achieve the return to the economic prospects that we saw so visibly before us before this pandemic. And we just think it's the right thing to do. And so the ICC stands for equitable access to vaccines, and it stands for the South Pacific, ensuring access for you, to all our friends there, because it's just the right thing to do. And in the end, that's what the ICC does. You know, we have a bold purpose to enable business worldwide to secure peace, prosperity, and opportunity for all. Our mission is to make business work for everyone, every day, everywhere. What we do is we help grow the global economy, we enable trade, and we ensure it's done in a sustainable manner. All elements that are so critical to the future of the South Pacific. And I'm also delighted to be able to share some time with you today, because I respect so much the work of our friends at the Asia Development Bank and at UNCITRAL. It's no doubt in my mind that a lot of the work we do, particularly in South Pacific, but in Asia Pac in general, would not be possible without our strong collaboration with the ADB. Let's face it, the work we're doing right now in Singapore on ensuring that we can take the whole trading world from analog to digital is enabled by our partnership with the Asian Development Bank. So I shout out to my friends there, and I shout out to the leadership of ADB during the course of this crisis. You've shown some real innovation and some leadership, which frankly has been lacking in some of the other regions. So a regional development bank, I think the ADB has led. And to my friends at UNCITRAL, let me make one observation. You have done the hard yards on putting together what we call the model laws to ensure that we can actually recognize legally a lot of the electronic transfer or documentations that we have before us. And it's the digitization of those documentation, it's the digitization of the trading world, which is enabled by the work you did on giving the right to actually have legal status to a number of these documents. You made that so critical. You made it actually easy to do. The tragedy is that it took a crisis for us to be able to get the attention of world leaders to actually adopt those model laws. But we could not have even had that opportunity if you had not done that work. So I shout out to you and I thank you for the work you've done. And I hope you also find a partnership with the ICC as we seek to take your pure work and apply it on a global basis through our Digital Standards Initiative in Singapore. Something that you can also rightly say is a consequence, a positive consequence of working with us. But importantly, positive consequence of the ICC, the Asia Development Bank, and UNCITRAL, understanding the challenging context we're in and doing something about it, which can actually help restore global economic growth by doing the pieces of work that are so critical to get that moving to digitization, moving to the recognition of electronic documentation, giving them legal force, and frankly helping the real economy, which is what we all do, and it's something that I'm extremely proud of. When I said what we do before, I talked about growing the global economy. I talked about enabling global trade and ensuring it's done sustainably. I think it's really important when you think about what we do, we should also think about how we do it. And one of the ways we do that is through respect for the law, the rule of law. It's a critical element in that. And we not only talk about how we do it by having a world-leading arbitral body such as the ICC Courts of Arbitration and the whole dispute resolution team, but we also do it by ensuring that that the court, the dispute resolution team operates in an effective way. So what we do, how we do it, and what enables us. What enables us when it comes to issues to do with making certain the world-class international arbitration practice operates. We actually need to ensure that it operates on a global basis. We're world-class, and that's the truth. And I'm proud to say, and I know, of course I would say, that the ICC Courts of Arbitration, the ICC dispute resolution processes are the number one, are the leading global, private, international dispute resolution body. And it's our independence and our commitment to doing things globally that's so important. And so ensuring that we are available, that we have a reach, not just in the north, but in the south, not just in the Northern Hemisphere, in the Southern Hemisphere, but also in the South Pacific is important to us as well. So it's really a great pleasure to be with you here. Pursuing a global framework for international arbitration was one of the ICC's actual earliest innovations to promote trade and investment, to enable trade and investment. That's what we do. But it's certainly not been our last. I think, as you would have heard from some of my earlier comments, the work we're doing on vaccines, the work we're doing on digitising the whole global trading environment, these are all new innovations, and these are all necessary to continue our mission of actually growing the global economy and enabling that for the world. But looking back, the notion that an arbitral award issued in one country would be enforceable in more than 160 countries must have seemed like an ambitious stretch back then to my forebears. Must have seemed a very ambitious stretch to have one arbitral award capable of enforcement in more than 160 countries. But that is exactly what we have done. That's exactly what we, the ICC and international arbitration community, have achieved. And having produced and been integral to the production of the first draft of the New York Convention back in 1953, thankfully before I was born, ICC continues to innovate and adapt the rules to the needs of business globally. We need to ensure all the time that the rules fit the context in which we operate, and that we operate to actually meet that context as well. In January of this year, we introduced new rules to help future-proof the ICC arbitration by specifically empowering tribunals to conduct digital proceedings in the manner they see fit. We needed to do that. We must do that. Because I said we need to ensure that we can operate in the context in which we find ourselves, and in a context where the possibility of human contact and actually being able to meet and actually have wet signature documents provided is impossible because of the restrictions and the close downs and lockdowns. We needed to ensure that we were actually able to empower tribunals to conduct proceedings on a digital basis. We've done that, and we've done that very successfully, I think. We've also adopted and adapted the rules to reduce the usage of paper because we're serious about sustainability. We're actually serious about that, one of our commissions, and it's one of the submissions we make to ensure that arbitration is sustainable, but also the reflection we have on diversity as well. Not only are we believing that arbitration should be sustainable, but part of sustainability is ensuring that it actually reflects the diversity of the world around us. And I think there would be no doubt in anyone's mind the decisions that have been taken as to the composition of the court, and in fact the new president that we just announced, reflect our desire to actually ensure diversity is actually recognised and represented within the ICC courts of arbitration. But we just don't talk about it, we actually do it. And that's something which is actually a remarkable feature of the constantly changing, innovating courts of arbitration, the approach we take. The new rules that we've adopted are particularly well timed in the context of the pandemic, and ultimately aim to ensure that ICC arbitration remains a living force, adapted to the demands of the global economy and designed with you, the users, in mind. One of the strengths I found with the ICC courts of arbitration and the whole dispute resolution area is its openness to change. Its recognition that being number one is not a God-given right. We have to work to maintain our position. And we work to maintain our position by constantly innovating, constantly thinking about the needs of the community that we serve, but also trialling, testing, pioneering, but also doing what we say we're going to do as well, by living up to our promises of diversity. And these changes and the openness to change sit alongside other bold steps we are taking to upgrade and make resilient the trade infrastructure on which the whole global economy depends. Building on our long-standing leadership in the field of trade finance, for example, we are working to digitise, as I said before, today's paper-based trading processes and modernise the use of standardised letters of credit, which, by the way, we also first introduced back in 1933. And we're also looking at one of our signature services, which is the ICC Incoterms, which we launched actually in the middle of the Great Depression in 1936, when the world was tearing itself apart, as an instrument that could continue to unite the world through commerce. We launched that in 1936. And one of our challenges now is to ensure that this signature service that we offer, Incoterms, is fit for the modern age. How do we ensure smart Incoterms operate? How do we ensure that we can develop an API to actually support and enable Incoterms? These are all things we're working on at the moment. Part of the constantly changing focus that we have at the ICC. Don't forget that one of our values is actually pioneering. Don't forget Another one of our values is connectedness. We need to remain connected to the communities we serve. We need to continue to pioneer. And we need to liberate ourselves from the past and ensure that we're ready, fit and able for the future. It's another one of our values. And always our final value is to be generous to each other, generous to the communities we serve, and generous to the history of the ICC, and hopefully by doing so create a stronger future as well. We see all these investments as part of the evolution of our ongoing mission to ensure that business works for everyone, every day, everywhere. And these innovations are all the more important as the pandemic has highlighted the fragility of global trade. Reviving struggling economies hit hard by the pandemic will require that we use all available tools to
providenciar
activity. And international arbitration is a proven
atividade económica.
A 2016 study by researchers at the IFC and University of Valencia, and I think the latter, also from Spain, Dr. Paniagua, is on the first panel, looked econometrically at the connection between signing the New York Convention and inward foreign direct investment. And that study showed that the impact was positive and significant. In fact, foreign direct investment rose 5-fold in the years after countries joined the convention. Embedding international arbitration into national legal frameworks then sends a strong signal that businesses can rely on effective dispute resolution to support their investment. Just as property rights are a pillar of a modern economy, de-risking investment requires that companies have confidence in a stable and efficient business environment. A study recently conducted by the Commonwealth Secretariat found that SMEs, we are in the end the voice of the real economy. We want to make certain that SMEs continue to flourish. And SMEs, of course, particularly in the Pacific, account for over 90% of economic activity. And actually, on a global basis, account for a similar amount in terms of global trading sector. But these SMEs are hesitant to invest abroad. Why? Due to uncertainty about the legal systems that operate in other economies and other countries. So effective dispute resolution helps to address these basic concerns harbored by businesses large and small operating across borders. As more and more countries are joining the New York Convention in the South Pacific, we're so pleased that the recent signatories include Fiji and Papua New Guinea, but also Timor-Leste. Welcome on board, Timor-Leste. And I know in signing, one of the signals that you sent in the statement you made upon signature was that you knew this would be a signal to the global business community that East Timor, the Timor-Leste is open for business, open for foreign direct investment. But we note that several South Pacific islands are yet to do so. So come on, if you need any support or help from us to argue the case with your respective governments, practitioners from those South Pacific island countries, please let us know, and we're happy to arm you with the advocacy tools required. The reality is that countries considering adopting the New York Convention can take comfort that while globally applied, arbitration is also the most local method of dispute resolution. One of the myths about arbitration is that it's for someone else. The fact of the matter is arbitration, the way we apply it through the ICC rules and the approaches we take, means it's for you. Global influence, regional significance, and local impact. That's what we do at the ICC in everything we actually create there. But when it comes to arbitration, we need to ensure, and we do ensure, that it's locally relevant as well. Whilst arbitration is a global framework, it's also tailored to be relevant at the local level and have impact there. Where a small firm expanding operations can have the same swift recourse to justice as a larger firm leveraging a global footprint. In fact, one of the pillars that we're working on at the moment with our Save Our SME campaign is how do we ensure rapid and effective access to dispute resolution for SMEs at a low cost. We think it's critical to get the real economy moving. And so ICC's rules enable this in dispute resolution by firstly administering a proceeding in the language in which the users desire to conduct it. Secondly, by ensuring the tribunal rules are based on the legal system chosen by the parties. And thirdly, by guaranteeing that the procedures governing the actual process will be the ones that the parties have agreed to. Global influence, regional relevance, and local impact. It's the opportunity that's provided by utilising and understanding the way the ICC Courts of Arbitration and Dispute Resolution operate. But it's also critical to understand that interlinking with the New York Convention, the importance of actually signing up to it, but also understanding the benefits that can actually accrue to economies. So when we talk about the challenges that this conference will be focusing on, we do think part of the future lies in actually effective recourse to dispute resolution, and we at the ICC stand ready, willing and able to ensure that what we do in delivering this world-class service is relevant, tailored and effective for you. Please never hesitate to ask for our help. Never hesitate to ask for our support if there's issues you need to actually argue with your government or with other regulatory bodies in order to ensure that you can apply fully the benefits of actually having access to justice through arbitration available. Thank you for your time. Again, I'm sorry I can't be with you. Enjoy the rest of the conference, and I look forward to the moment when we can all be together again. Thank you.
Thank you very much, Mr. Denton, for those remarks, and of course to the ICC for their support in relation to this project. It won't surprise anyone to know that we are slightly over time, and as a result, I have to deliver the bad news that our coffee break will be a little shorter than we had anticipated. We will now take a short break. We'll take a 5-minute break instead of a 15-minute break so we can stick to the balance of the schedule. It's important that we're all here for the plenary sessions, which will start at 15:15 Sydney time. So please take a break now, and we'll see you in 5 minutes' time. Thank you.